Good morning, everyone. Thank you for joining us. My name is Zaria Dogan. I am the Growth Marketing Coordinator here at Higher Level. You have joined our HiNotes webinar today. Super excited to have Corey Franklin with us today. He will be presenting on employee handbooks and work rules. I'm super excited to hear what we will learn today, as this topic was very much suggested. So super excited. But before we get started, I just want to cover a few housekeeping items. This webinar will last less than an hour. Everyone on the call is in listen-only mode, but you do have the ability to contact us through the chat, and I will answer those questions as Corey is going through the webinar. So before we get started, I would just like to introduce Corey. Corey Franklin is the office managing partner at Ford Harrison St. Louis office. His legal practice is focused on the representation of management in labor relations issues and employment law disputes. A majority of Corey's practice is dedicated to helping clients, both unionized and non-unionized personnel, when facing labor relation issues. He is highly skilled in advocating for clients in complex collective bargaining negotiations, labor arbitration, and grievance proceedings, union organizing campaigns, strikes, and administrative proceedings before the National Relations Board. Corey represents private companies as well as public entities, including municipal bodies and collective bargaining, state labor relations, act compliance, and contract arbitration resolution proceedings. Corey is a member of Ford Harrison's labor law and healthcare practice groups. He has advised healthcare systems, hospitals, and other healthcare providers across the country regarding organizing campaigns, collective bargaining, and contract administration. Corey spends a significant amount of his time counseling for profit, nonprofit, and public sector employers within the healthcare industry, and otherwise regarding both preventative strategies and rapid response measures to quell union organizing efforts in their early stages. Corey clients range in the size from major multinational companies to small local businesses. He represents companies in a wide variety of industries, including manufacturing, public transportation, law enforcement, and the unique, highly regulated healthcare industry in both labor relations and employment matters. Also, if you would like to join us for our next HiNotes webinar, it will be on October 25th, and we will be covering employment law updates for 2023. And we will be sharing more information about that here in the next few weeks. Now, Corey, I hand it over to you.
Thank you so much. I appreciate everybody joining us this morning. This is an exciting time to be what I would politely refer to as a labor law nerd. There's a lot going on as it relates to the National Labor Relations Board, and in particular, many of the things that are occurring at the National Labor Relations Board are particularly relevant to employers that don't have unions. Employers that already have unions have kind of acclimatized themselves to what it's like to have a union, and there are certainly some new and novel issues that the current board is raising that make that relationship a little bit more challenging to navigate. But really, this has become a much bigger issue for non-unionized employers, as we'll talk about today, for a couple of reasons. But as the title of the program says, the devil is in the details. And as we'll talk about today, the National Labor Relations Board is very interested in your grammar, your style, your diction, your punctuation, as it relates to all of your policies. And unfortunately, that puts a lot more pressure on HR professionals who, typically have not had a lot of exposure to the National Labor Relations Board, traditional labor law issues, or navigating some of the challenges that arise under Section 7 of the National Labor Relations Act when, disciplining, discharging, and performance managing employees. So today, Our agenda is pretty straightforward. We're going to talk in basic terms about the National Labor Relations Act, about protected concerted activity and how that works in action. We're going to talk about the board's treatment of employee handbooks and rules, and the board's recent decision in Stereocycle and what that decision means for employers, not just unionized employers certainly, but primarily non-unionized employers. So without further ado, let's just get into the mix. And as mentioned at the outset, I'm sure folks are going to have questions as we go. This is you know, it seems pretty formal because I'm wearing a tie. However, I just assume that if you have questions, hack them into the chat, and I'll answer them as we go. It's much easier to do that than try to backtrack and keep train of thought. So don't hesitate to chime in. In any event, let's start with the National Labor Relations Act. What is the National Labor Relations Act? Well, the National Labor Relations Act is, you know, pushing 90 years old. It was enacted in 1935, a product of, you know, the times. You know, in the 1930s, we're coming out of the Great Depression. We're coming out of a history of a period of labor history in this country where strikes were rampant, where union misbehavior and employer misbehavior was rampant, where we had you know, not just strikes, but we would have, you know, things like, you know, unions, the Molly Maguires kidnapping management functionaries and leaders and their families, and fistfights breaking out, and companies hiring Pinkertons to bust unions. It was a real free-for-all. And, you know, so what the National Labor Relations Act attempted to do was to create order from chaos. And as a function of that, of the strictures that were put in place by this federal law to govern labor relations and the relationships between unions and employers, and the rights that employees had to form unions, as a function of that, there's a key provision here called Section 7, and Section 7 defines the full panoply, the full array of rights that employees have under the statute, and is really the keystone upon which that this entire statutory scheme is crafted. So this is a bit of a straw man, true or false question here. The National Labor Relations Act, true or false? The National Labor Relations Act covers only unionized employees, and the National Labor Relations Board only polices unionized workplaces. So as a non-union employer, I don't have to worry about this. True or false? Now, you guys can't verbally express yourselves. I'm assuming that if you could hack into the chat as quickly as I can talk, you'd all say false, and you'd be right. And the reason why is because the way the National Labor Relations Act defines employer is any employer. It's basically any employer that's not a state government, that's not the Federal Reserve Bank, that's not a local political subdivision, or a railroad or airline that are covered by the Railway Labor Act. So anybody that is acting as an agent of an employer or an employer directly who's employing employees is going to be covered by the Act. That's a pretty broad definition, and what that means for you as HR professionals is that with very limited exceptions, odds are you're going to be covered by the Act. Now, the Act is administered by a federal agency called the National Labor Relations Board. Like the Act, it was created and put into place in 1935. And unlike some federal agencies, it is characterized as an independent federal agency that is separate and apart from the Department of Labor or the Department of Health and Human Services or the Pension Benefit Guaranty Corporation or any of these specific federal agencies that have a number of different divisions. It's an independent body. And its general counsel and board members are appointed by the president and subject to advice and consent of the Senate. And their charge is to administer elections and to enforce the Act as it relates to unfair labor practices. Now, as it so happens, although National Labor Relations Board employees are federal agents, and you'll see their, in their email footers, it'll be field agent or a field examiner or board agent. And while they have the ability to issue subpoenas and conduct investigations, unlike some other federal law enforcement agencies, there is no NLRB jail. Now, typical remedies under the National Labor Relations Act include things like notice postings. You'd have to reverse adverse employment decisions, back pay. Under some recent case law that came out this year in a case called Thrive, I guess within the last year, December, to be specific, of 22, that has been expanded by the board to include compensatory damages for all direct or foreseeable pecuniary harms suffered because of a labor violation. So what does that amount to? So let's say that we terminate someone under a rule in your handbook that the board finds unlawful, and that person lost their medical coverage because they couldn't afford COBRA and were in a serious auto accident and incurred thousands and thousands of dollars in medical costs because they were uninsured at the time. Under the current board's view of its remedial powers, as it's being enforced under this case called Thrive, you as the employer would be on the hook for those medical costs if your termination decision was deemed illegal. So other things like credit card debt or other costs associated out of an unfair labor practice. So kind of foreseeable, what they characterize as foreseeable economic costs resulting from a discharge, mortgage payments and things like that. The NLRB has two elements. The General Counsel's Office is responsible for enforcement of the act, and the board itself is responsible for administering elections and for deciding cases that are brought by the General Counsel up through its judicial division called the Division of Judges, and issuing rulings on what is and what isn't a violation of the act. They don't typically, although they have more so in recent years, they don't typically create a lot of rules like other federal agencies do, like the EEOC or OSHA or the Department of Labor. Most of the rules that they create are created through the judicial decision-making process. So the General Counsel, after an individual or a union would come in and file an unfair labor practice charge, the General Counsel would determine whether that charge has merit. If it does have merit in her estimation, she would then issue a complaint and litigate that case against the employer before an administrative law judge, get a determination, and if the parties didn't like that determination, they could appeal to the full National Labor Relations Board in Washington, D.C. The current General Counsel, appointed by President Biden, is in many ways very controversial in employer circles, certainly, and viewed as a very zealous pro-union advocate in labor circles. She was previously, immediately prior to her term as General Counsel, she was in-house counsel for the Communication Workers Union. Before that, she was a long-tenured assistant general counsel at the National Labor Relations Board. She is very smart. I've had the pleasure of speaking with her and meeting with her on a number of occasions, and she's very bright. She understands the National Labor Relations Board top to bottom from her prior employment with the board, and she has a very nuanced and thoughtful approach to advocating zealously in favor of a lot of the stances that unions would prefer. She views her authority very extensively and expansively, and views the rights protected by the Act very extensively and expansively. She has made no bones about the fact that she is going to be very aggressive in what she views as her role as fighting back against unlawful terminations and proactively trying to enforce very broad, very aggressive remedies against employers that she believes are violating the National Labor Relations Act. In 2021, when she first came into the position as general counsel, she issued a memo, as most general counsels new to the job do, called the mandatory submissions to the Division of Advice, which is essentially highlighting a list of cases that she desires to litigate in an effort to overturn existing National Labor Relations Board law. And that was, in no uncertain terms, a greatest hits list of organized labor's objections to various National Labor Relations Board decisions over the course of the last 75 years. 40 of those decisions in particular were handed down during the Trump era and were handed down in a fashion to essentially reorder labor relations policy consistent with what it had been prior to the Obama administration. You'll hear this throughout the course of the presentation today. The National Labor Relations Board has a tendency to vacillate back and forth, depending on who is in office, and the current administration is no different. So we talked about Section 7 of the National Labor Relations Act, and I told you that this is the keystone around which the entire structure of the act is built, and that is not understated. Under the National Labor Relations Act, employees have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. Now, we could spend hours just parsing the language in Section 7 of the National Labor Relations Act. For our purposes today, the most important elements of this aspect of the statute are the fact that employees have the federally protected right to engage in other concerted activities aside from just union organizing for mutual aid or protection, which means speaking out on issues, taking action on issues that are relevant to wages, hours, and other terms and conditions of employment in the workplace in a fashion that is either inclusive of others in a group and how these issues are addressed, or by way of the employees' engagement in these issues involving other people. Now, the National Labor Relations Board defines protected concerted activity, and again, primarily through its decision making at the adjudicative level. So it refers to the notion that an injury to one is an injury to all. So if one employee is adversely impacted by an unlawful policy or an unlawful application of a policy, the board views that as an injury to everybody within a unit of employees that are subject to that rule. The board is of the view that employee activity is concerted and engaged in for the purposes, or is concerted when it is, is protected when it is concerted and engaged in for the purpose of mutual aid or protection. So it has to be an issue or an action taken that is for a group good and not an individual complaint, an individual gripe. My paycheck is wrong. My schedule is wrong. It has to be something that is broader than just an individual employee's issue. And there has to be an object to induce or initiate or prepare for group action, right? So it has to be, I have this problem and I want you to do something about it, which would affect a group of people. I have an objection to this policy and its application to me and to others. The concertedness and mutual aid or protection aspects of what constitutes Section 7 activity are viewed under an objective standard. And the key is, what is the employee seeking to achieve, not what their motive is, right? And the motive isn't relevant to whether it's for mutual aid, and it's not relevant to whether the issue is concerted. It's more a function of the issue. And what the board's looking at is whether there's a link between the activity and something that concerns workers in the workplace or employee interests that are unique to them as employees. And a single employee can, in and of themselves, engage in protected concerted activities simply by going through the action of asking others to join. So let's talk about what this protected concerted activity looks like in action. So what are some examples of, and we're going to refer to this, I can't help myself, you know, it's I think day 3 of law school, they tell you to use acronyms for everything. So if I fall into calling protected concerted activity PCA, that's what I'm referring to. PCA is protected concerted activity. What are some good examples of PCA? So again, the conduct has to be both concerted and for mutual aid and protection. And there has to be that causal link. And, you know, you're looking at a definition that's designed around something that's beyond just the employee acting on their own. So we're talking about 2 or more employees in most cases discussing their wages, discussing a safety issue in the workplace, discussing unfair treatment by a supervisor, presenting, for example, a petition to management about the fact that there have been a whole rash of what they view as unfair schedule changes or unfair assignment of overtime. Facebook posts that are circulated among other people in the workplace, sometimes in a specific Facebook group that is in, you know, targeted to just being a workplace focused group, or to other individuals that are Facebook friends or connected somehow in various social media mediums, addressing workplace issues where it is, by the way it's written, targeted to other people that are involved in that workplace. It could be action or speech by one employee on behalf of the group. So if I go into my managing partner's office and say, Al, everybody in St. Louis is really tired of the coffee. We need better coffee. I'm engaging in protected concerted activity because I am complaining on behalf of other employees about an issue that is a working condition, namely the coffee available in our break room. And I am attempting to achieve some type of a group goal as opposed to my personal gripe about the coffee. Oftentimes this comes up in the context of issues that, you know, that HR people are really familiar with. It may be harassment claims, and I use harassment with the small h and not with the capital H that constitutes unlawful harassment. It could be harassment by a supervisor who is being just obnoxious in the way that they are treating employees or making their lives more difficult, although not because of age, race, sex, national origin, etc. But again, a personal gripe, I don't like my supervisor, is not protected in concerted activity. It is protected concerted activity if I say, I hate my supervisor, so does everybody else on our shift, and you need to make a change because we're not going to put up with it anymore. That goes into the arena of PCA. Again, this is going to depend on the totality of the circumstances, and it can apply to situations involving both statutory employees, and that includes job applicants, by the way, when they are advocating on behalf of non-employees like contractors or agency temps or interns. So for example, if an employee says, I don't like the way the supervisor treats all of the temp labor that's outside doing landscaping work, he's really rude and sexist and makes crude remarks. And, you know, not only should we not have to put up with that as employees, but none of these poor landscapers should have to listen to that nonsense either. That could certainly constitute protected concerted activity under the Act. And the board is going to look at all of the evidence in what tend to be very fact-intensive cases with voluminous records and lots of documents and lots of testimony to try to figure out what is and what isn't PCA. As I alluded to earlier, the general counsel at the outset of her tenure as general counsel put forth this memo called 2104, GC 2104, asking regional directors and regional attorneys to send cases to her office so she can make a decision on prosecution to change the law involving certain issues that are of importance to her political agenda. One of those subjects is what's called inherently concerted activity. And historically, the board has said anybody that's complaining about wages, unless it is very specific to something nuanced about a payroll problem to them, they're generally engaged in concerted activity and protected activity because they are complaining about wages for everybody. If you're saying we are paid too little, that is inherently a protected concerted complaint. And she is pursuing cases to expand this in the official dogma of National Labor Relations Board decisions to issues like discrimination, harassment, retaliation, OSHA complaints, and the like. She recently issued this year in March an updated status update on the mandatory submissions to advice memo. What cases still need to be sent to her, what cases have already been processed by the board, which is quite a bit. And among them, again, is this issue under hood view vending as to what does and what doesn't constitute inherently concerted activity. Now, from the standpoint of a management side practitioner, I would be of the opinion that issues relating to discrimination, harassment, retaliation are not inherently concerted because they are specific to the treatment that an individual employee received. And unless you are making a complaint about systemic discrimination in the workplace that impacts multiple employees, that there's not even an arguable basis for making that assertion. But that's going to be something that comes up to the board, and that becomes relevant as it relates to what we're talking about today in handbook policies, because we all have a whole host of provisions in our handbooks that deal with discrimination, harassment, retaliation, how we process investigations and complaints, and the obligations that we impose on employees and treatment that we have for employees in the course of navigating those issues.
Hey, Corey, we have a question coming in. This is from Vina. She said, do you offer closed captioning?
I would be happy to if I knew how to do that. If you are able to tell me how to do that, I am happy to offer closed captioning. I am not seeing a closed caption option on the form. Sorry. If you're able to break in and tell me later, I'm happy to do that.
That was the only question so far.
Okay. And this has become this notion of inherently concerted activity has become a real hot topic for a number of reasons of late, not the least of which is the fact that our workplaces have become inherently more politicized. And there are a lot more discussions of, broader global issues, whether it's immigration reform, whether it's Black Lives Matter or Me Too issues, that have become regular topics of discussion in our workplaces, and employees more and more frequently are becoming engaged outside of the workplace and advocating for these issues. And it's the current board's view that their personal advocacy on the issues of importance to them when it comes to the workplace becomes protected concerted activity. So there's a whole host of cases pending before the board right now that relate to workers, particularly in retail settings, wearing pins or insignia that say Black Lives Matter, or issues concerning LGBT. I'm gonna muddle it, but sexual orientation related issues and sexual identity related issues, political issues, immigration related issues. The board has taken position that even an employer policy that puts certain restrictions on what can and can't be worn, that those restrictions can be unlawful unless there are special circumstances that justify them. And certainly social media activity concerning these types of issues, and solicitation of coworkers concerning these types of issues can be PCA, and that's notwithstanding what policies you may have regulating that type of conduct. So if you have an employee who at work is engaged in kind of a loud and argumentative and disruptive discussion about Black Lives Matter issue, or a political, an immigration reform issue, getting into it with someone who has an opposite position to them in a break room, and you take action against them, when if both of those people are on a break time, that's going to be viewed as by this current board, that very well may be viewed as a violation of the act, and a policy that would permit you to take that type of an action would be viewed as unlawful. All right, so let's talk about how the board treats employee handbooks and work rules. Basically, the board looks at work rules and kind of puts them in three buckets, and more explicitly in three buckets, as we'll see, as a result of a case that came down during the Trump administration. But previously, at least as a conceptual standpoint, when they look at a handbook policy, they look at it and kind of try to put it in one of these buckets. The first would be a rule that explicitly restricts activity protected by Section 7 of the Act. The number one example of a rule that violates the Act is a rule that says you are not allowed to talk to others about your wages or benefits. That is, as it's applied to anybody who is an employee covered by the Act, which is essentially anybody that's not a statutory supervisor or a manager, that is per se unlawful. So that would be an illegal rule. Another example of an illegal rule would be a solicitation policy that prohibits solicitation of the distribution of materials to employees on non-working time in non-working areas. Often employers, in an effort to use shorthand language, will say you can't distribute materials or solicit coworkers on company time. Those are different.
We have another question.
Sure.
Houston said, can you prohibit discussing politics in the workplace?
That is a very, very challenging issue. I would say no, you can't. Certainly, you can tell employees that they should not be, engaging in disruptive behavior when they're working, but on non-working time, which would be breaks and meal periods, and in non-working areas, namely break rooms, bathrooms, hallways, the parking lot, the smoking shed outside, you can't regulate their behavior in those areas, even though they may be on the clock. And we're going to get into some more of that as we go on here, because that's kind of a reoccurring issue. Efforts by employers, particularly in light of recent more zealous union organizing efforts by a whole host of different unions, really has stressed employers, particularly those that are less familiar with the National Labor Relations Act and what it allows and doesn't allow, And as a result, employers are kind of put in a position where they're trying to enforce rules that just on their face are not going to be lawful. And as we'll see in a second, put them in a position where they might end up with a union without ever even getting the chance to have an election. All right. So the second bucket of rules are rules that are adopted in response to activity that's protected by Section 7. Again, the hallmark example of this is an employer who hears through the grapevine that there's union organizing going on and says that employees are no longer permitted to gather outside the facility before and after their shifts, and no more than 3 people are allowed in the break room at any given time. Or that, for your example, that you're not allowed to discuss union issues at work. The discussing union issues at work rule has a number of problems with it, but rules that are put in place in an effort to curb forming, joining, assisting a labor organization, or banding together for purposes of trying to facilitate a union in the workplace would be violative of the Act. The third bucket of rules are rules that are applied to restrict activity protected by Section 7. Now, what does that amount to? That is a rule that on its face is perfectly acceptable. It may be a rule that says that if you are in a discussion, if you are part of an investigation of an HR complaint concerning discrimination, harassment, or retaliation, you are not to discuss any issues that are addressed in the course of your investigatory interview or any facts concerning the investigation with any other employees. Now, that's a perfectly sensible rule from our perspective as HR professionals and as a management side labor and employment lawyer. We want to have a good investigation. The board, under current leadership, is of the mind that employees inherently have the right to discuss these issues, and that trumps the employer's right to conduct an appropriate investigation under Title VII. So we'll discuss some strategies for addressing that, but that's one example. So here's some examples of some facially illegal rules. I'm not going to spend your time reading these to you, but for example, rules prohibiting employees from speaking with the media at all, as opposed to just speaking as holding yourself out as a representative of the company. Rules prohibiting employees from recovering back pay in the event of a National Labor Relations Board order or an EEOC order. Non-disparagement rules applying to discussions among employees. The board is of the view that labor organizing and workplace issues, for whatever reason, justify all types of unseemly behavior that we would never permit in any other context. That's one of the more disappointing positions that this board has taken. We'll talk about that and its decision in General Motors here in a little bit, but that's one of the issues that they have. And rules concerning confidentiality. This current administration hates anything confidentiality related. They always want employees to be able to discuss everything, irrespective of what impact that may have on either your own investigations or whether folks have signed confidentiality agreements. You've probably heard about this case, McLaren-McComb, that came down several months ago, saying that confidentiality, non-disparagement provisions in release agreements, just giving them to someone is a violation of the Act. Some facially neutral rules that are going to be subject to this very nuanced board interpretation. Confidentiality rules applying to business information. They're going to look at what types of information and what contexts the rule exists in your handbook or in your policies. Maintaining a harmonious workplace. How is it described? Who is it applied to? What examples do you have as to what is and what isn't acceptable behavior? Accessing a facility outside of assigned working hours. What is your explanation for it? What's going along with this, and why are you doing it? What is the context? Content on social media. I'll tell you just as an aside, as a management practitioner for well over 24 years, or whatever it is now, I can tell you there is no single provision in employee handbook that I would tell employers to remove faster than their social media policy. It's a waste of paper, it's a waste of time, and odds are that you have a whole host of other vehicles at your disposal to address employee conduct that you find problematic under your social media policy. So a little free legal advice. If you need some help getting it out of the policy and tuning up other policies to fill the gap, don't hesitate to give me a call. But that's really that's the bane of management lawyers' existence, those social media policies. In addition, the board applies a very similar rule concerning uniforms, badges, logos, stickers, to the standard that they apply for handbooks. And basically, it's when we discuss the stereocycle test that's now in place, you have to be able to provide a substantial justification for why you have any type of a uniform policy at all. And if employees are violating the policy now, and you're not strictly enforcing it, even if you have a substantial justification for enforcing a uniform policy, the board's going to find that you have engaged in unlawful conduct if you start enforcing it to prohibit buttons or insignia or stickers or whatever about unions or other issues that are subject to debate in the workplace. So again, some rules that may impact the exercise of Section 7 rights. Rules that impact employee speech and expression, particularly stuff that impacts conduct outside of working time. Rules that can be construed as inhibiting good faith dissent against company policy, against company action, against supervisor direction. Rules that compel strict confidentiality. Strict confidentiality is going to be viewed with a very discerning eye by the board. And any rules that regulate how employees interact with one another. Often you're going to have legitimate bases for having some of these rules, but they're so fact intensive in their analysis of them that you need to be very, very careful if you're going to have rules that touch on those subjects in your handbooks or your work rules. So let's talk a little bit how the board looks at these types of rules. Under Republic Aviation, going back to 1945, so 10 years after the act was put in place, the United States Supreme Court, in a case called Republic Aviation, said, look, the maintenance of a work rule that interferes with an employee's exercise of their rights violates the act. Just having the rule, whether you enforce it or not, having the rule there inhibits them from engaging in conduct because the employee works for you and they're not going to engage in conduct that they believe is going to expose them to discipline or discharge. The two key issues that they look at is the appropriate principles for evaluating the impact of the rule on their exercise of the rights, and how can they ensure that the rule's impact is minimized in light of the employer's legitimate business interests. Now, over the course of the last 25 years, so going back to the 90s, when President Clinton was in office, there have been 4 different standards that have been used to analyze whether work rules or handbook policies violate the act. And I'm sure everybody that's on this call has had some measure of frustration with trying to go through handbook policies as these board standards have waxed and waned and vacillated over the years. There's probably 1,000 different webinars and seminars that folks went to during the Obama administration when the board was particularly zealous about targeting workplace rules and was seemingly inconsistent in how it was applying the act. There was no predictability, and it really came down to, seemingly what the National Labor Relations Board and the General Counsel had for breakfast as to whether they were going to prosecute issues and how they would decide them. So out of that, for a 6.5-year period, from 2017 to 2023, we had a very predictable 3-category test that was very easily applied and that provided employers a chance to kind of take a deep breath and go back to more important things than parsing all the commas and all the split infinitives in their employee handbook. And during that period of time, employees who are not labor lawyers, let alone HR people, had no issue understanding what their obligations were in the workplace. But that brief reprieve that we have is now ended. And in a recent decision from about a month and a half ago, called Stericycle, the board made a tremendous shift in how it's going to look at handbook policies and workplace rules. And it's a shift that builds on tests that were developed in the Clinton administration and the Obama administration, and creates a burden shifting standard that is extremely difficult for employers to successfully navigate. What's worse is shortly after that, the board came down with a decision called CMEX Construction Materials, which imposes a new framework for union elections and fundamentally changes an employer's ability to ensure that its employees have the ability to have a secret ballot election and have a free and fair choice to determine whether they want to have a union. And the determining factor is whether there were whether the employer engaged in unlawful conduct during the period that a union demanded recognition without an election. And if there was any unlawful conduct, the board is going to issue what's called a bargaining order, and that bargaining order will compel you to negotiate with the union, even though the employees didn't actually elect the union as its representative. So that puts an even greater emphasis on making sure that the policies that we have are compliant, because if the union comes knocking and has a bunch of authorization cards from your workforce and you're maintaining an illegal rule, even if you haven't enforced it, as we said under Republic Aviation, the mere maintenance of that rule is an unfair labor practice. And once you have the cards in hand and then commit that unfair labor practice, you all of a sudden have a bargaining obligation and never saw it coming and never had an election. So let's talk about how the standard is developed. The first iteration of the standard was in Lafayette Park Hotel. This was a Clinton administration era case, and it was about a 6-year application. And basically under Lafayette Park Hotel, the National Labor Relations Board said that if a rule in its reasonable reading was not unlawful on its face, a 2-factor test would apply. If the rule does not explicitly restrict or inhibit an employee's exercise of Section 7 rights, it'll violate the act if it can be construed as prohibiting Section 7 activity, it was issued in response to Section 7 activity like organizing, or it was applied in a fashion to keep someone from engaging in Section 7 activity. So you're trying to keep someone from engaging in an organizing campaign. I don't know what just happened. I apologize. Okay. So where the rule doesn't reference Section 7 activity, they're going to conclude that a reasonable employee would read the rule and apply it as a normal human being, and non-labor lawyer would apply the rule. And as the board noted, doing anything otherwise would be unreasonable. Now, that test existed until, excuse me, something happened here. Until Lutheran Heritage. And in Lutheran Heritage, as we said, we had these 3 factors. And that notion of unreasonability from 2004 to 2017 was the key. What is a reasonable employee going to view this rule as. And under the Obama board, the view of a reasonable employee was very expansively viewed as a reasonable employee who was very concerned with organizing a union. And as you'll recall from, and undoubtedly from a whole host of seminars and whatnot, that was applied in a fashion that rendered most policies, particularly social media policies, unlawful because they were way too broad. Boeing brought a 3-factor test that said if the rule is on its face neutral, and or alternatively that the adverse impact is outweighed by the employer's justification, it's going to be valid. Category 2 rules are rules where it's tough to tell and they'll give them individualized scrutiny, and category 3 are rules that are patently unlawful. And under that standard, as explained in a later case, the board had the board had the obligation to prove, the burden to prove that on balance, a rule would interfere with protected concerted activity, notwithstanding the employer's legitimate justification. Under Stereocycle, the new case that just came down, basically, they say, look, employees are economically dependent on their employer for work, and what's going to happen is they're going to interpret a rule and evaluate rules on the basis of an economically dependent employee, one who is engaged in or wants to engage in protected concerted activity and is afraid of losing their job. And if they can show, and if the board can show that the rule would have a reasonable tendency to chill an employee from engaging in Section 7 rights, the rule is going to be presumptively unlawful. And if the burden, if the general counsel for the board meets that burden, the rule will be deemed unlawful unless the employer can show that there's a legitimate and substantial business interest that it cannot advance without the rule as written. So stated differently, it can't revise the rule or more narrowly tailor the rule to meet its interests. That is a virtually impossible standard to meet because most any rule, you can move a comma around, you could change a word around, and it would be more acceptable to an increasingly pedantic national labor relations board. This is a very bad development for employers. As I said, this is a very hypersensitive approach that the board is taking. It's a very high burden, similar to the rule it issued in Tesla on uniforms and insignia. It is a very high burden, and your rules are going to be, in all likelihood, presumed unlawful in most cases, and you have to prove that they are lawful and your justifications are legitimate, and there is no other way that you can revise your rules. So we better be right the first time. The standard in this case is retroactively applied, which means that it applies to rules that predate Stereocycle. So if you had an old rule that you applied to someone's termination, the current Stereocycle decision goes back and makes that decision subject to an unfair labor practice charge. So the takeaway is we've got to be a lot more careful and a lot more adept at dealing with these issues as HR professionals. So what does this mean for you as employers? One, the typical process of a union organizing campaign has been turned on its head by the board's decision in CMEX. This has now become a gotcha game. This has now become much more of a demand for recognition and card check process than an election process. And the board is about to issue a rule as it relates to what are called blocking charges, which a party that is not filing an election petition, so what's called the non-petitioning party, can file a charge and stop an election. This is important because under CMEX, the board presumes that if the union has claims that they have signed cards from a majority of employees, that the employer has an obligation then to file a petition for an election. And it has 14 days to do so. If it doesn't, the bargaining obligation exists. If it does, the election process goes, but if there's any unfair labor practice charge committed during the election period, the board will issue a bargaining order. when the blocking charge rule is changed, what will happen is the union will make a demand for recognition, giving cards. You'll file your RM petition as a dutiful employer, so you can have an election. Your employees can exercise their free choice. And then the union is going to file a blocking charge, an unfair labor practice charge, and ask for the election to be blocked. So employees will never have the opportunity. And with these increasingly lowered standards, inevitably, it's just going to be a parade of bargaining orders that the board is issuing. So as a result, the only thing that we can do, given the CMEX predicament that we find ourselves in, and with any unfair labor practice implicating a potential bargaining order, this is a big problem. So what are we going to do? Since 8A1 conduct, which is typically the section of the act that they would allege was violated if you have an unlawful rule, since that is viewed under the act to effectively constitute interference with an election, and any unfair labor practice during the critical period would require setting aside election under old board law. Under CMEX, just having an unlawful rule is going to mean that you have a bargaining order. And Stericycle and CMEX are both retroactive. So to the extent that you have ongoing organizing campaigns right now, all of these issues are live for you in the immediate term. So what are we supposed to do? Well, as it relates to workplace investigations, we need to make sure that the rules that we're enforcing, as it relates to behavioral standards, attendance, conduct towards supervisors, are lawful. That we, to the extent that we can clarify the types of conduct that are not subject to the policies, we need to do that. As it relates to an attendance policy, if we require that someone call in and notify us of the reason for their absence, that provides us a measure of protection, because if they say that they're on strike or they are protesting, we can avoid imposing discipline because that would be protected concerted activity. As it stands right now, I'm assuming most of us have an attendance policy that would constitute a violation of the act, because it doesn't provide any formal exception or any vehicle for an employee to request an exception to the policy that would allow them to engage in protected concerted activity. We need to make sure that we are able to enforce the rules that we have about the investigative process. Stericycle overturned a case called Apogee Retail, which said that a rule requiring employees to maintain confidentiality during an EEO investigation is not lawful. There is a question as to how far Stericycle went in overturning that, but as it stands right now, the General Counsel is trying to get an explicit overruling in another case that's pending before the board. So I suspect that that's going to happen within a matter of months. So what language are we using to frame an employee's obligations in the course of an EEO investigation, a retaliation investigation, an investigation of just employees behaving badly and talking amongst themselves or complaining amongst themselves about how they're being treated? The board, again, is taking an increasingly expansive view of what constitutes protected concerted activity. And discipline or a discharge that might not have been scrutinized before, the typical white male under 40, is much more of a risk of litigation now than it ever was. And because the board is imposing much more substantial remedies, compensatory damages, than it has in prior cases, oftentimes the liability at issue may exceed what you may be liable for in the context of your typical EEOC or MHRA or IDHR charge. So as HR professionals, we all have to up our game as it relates to recognizing our obligations and our responsibilities and counseling employers about the National Labor Relations Act. Best practices, first and foremost, handbook hygiene, as I describe it. You need to take a holistic view of your handbook, Marie Kondo style. Remember, if it doesn't give you joy, get rid of it. What is the purpose and value of each policy that you have in your handbook? Do you actually need it? What policies are there? What policies aren't there and don't need to be there? There's a great scene in the movie A Few Good Men with Tom Cruise where he proves that one of the people that's testifying on trial that the handbook for the Marine unit doesn't tell you where the mess hall is. You don't need it, and you don't need a handbook provision to tell you where the break room is. The more stuff you can take out of the handbook, the better. We need to make sure that we're reviewing policies that we do need to keep in the handbook for compliance, making sure that to the extent that we have this stuff, that it's stated as expertly as possible, using the decisions that are coming down and are handed down. There's a general counsel memo that came out in 2015. It's called General Counsel 1504. That's a good starting point for a number of these policies, as I expect that the board is going to be interpreting Stericycle in a fashion that's consistent with some of the determinations that were made under the old Lutheran Heritage Standard. If you have rules that are going to be viewed as explicitly prohibiting Section 7 activity, let's identify them now and get them out of the handbook now. The sooner you do it, the less potential impact it can have on a union organizing campaign and waking up one morning and all of a sudden realizing that you're now an LR professional and not an HR professional. Making sure that we don't have rules that are talking about conduct that's offensive to other employees or prohibiting disclosure concerning certain types of business information that would, while ordinarily we would view it as stuff that we should be keeping confidential, would also tread into the area of information that would be useful for employees in the course of an organizing campaign. As it relates to confidentiality, I have an example here of a confidentiality provision that the board has found lawful. There are confidentiality provisions that do work. This is just one example, and I know we'll be circulating the slides to attendees here, and so you'll have that available to you. A lot of folks ask about savings clauses. Can we just have something at the end of the handbook that says that nothing in this handbook or nothing in these policies is viewed as a violation of the Act? Well, it helps, but mostly the board under a case called Macy's Inc. Is going to say that that's just not enough because it's too attenuated from the rule in question for an employee to be able to recognize what is and what isn't covered. To the extent that you want to use a disclaimer in particularly sensitive rules, it's going to have to be pretty broad, and it's going to have to be something that you're probably not going to want to have in your handbook, because it's going to say that the rule should, and there's a typo here, this rule should not be interpreted as restricting, limiting, or in other way inhibiting employees from exercising their rights under the Act, essentially. I'm not going to read you the whole thing. But the way the board looks at this, if you don't have that type of a disclaimer in every rule, that is going to be problematic. It's not going to be a save-all for all rules. So I have busted my time by a full 4 minutes, and I apologize. But if there are questions, I will take questions until the last question has been answered. And if you would like to ask, I know we have folks muted, but if it's easier to ask them orally, I'm perfectly happy to answer them that way now that the formal portion of the presentation is done.
All right. I'm not seeing any more questions come in.
Okay.
Well, thank you, Corey.
You bet.
Also, if you want to send me that presentation for anyone that would like it, go ahead and you can email me at hello@higherlevel, and I'll send that to you if you would like the presentation. As well as, Corey, is your contact information in that presentation as well?
It'll be in there. You bet.
Okay, sounds good. Well,
Thank
yeah, I was even thinking myself while you were presenting, I was like, well, I could really share this with our team. I mean, we have a team that handles our handbooks, and I mean, just to stay up to date, like you said, handbook hygiene. I mean, truly, those things were so important. So I'll definitely be sharing that PowerPoint. Um, and Kurt says, thank you, Corey.
Absolutely. Thank you. Thank you for joining.
All right. Also, if anyone is in need of handbook assistance, feel free to reach out to me at hello@higherlevel.com, and I'll connect you with the person that handles our handbook. And if there's no more questions, okay, I see. Okay, Vina, I will get you that presentation. All right. Well, thank you again, Corey. This was great.
My pleasure. Thanks everybody for joining.
Thank you. Have a good day, everyone.